Much of the discussion to date on the design phase and construction phase risk management issues that we've covered assumed participation of the design professional in a project delivery system commonly referred to as design, award, build, or design, bid, build. This linear or sequential approach has been the dominant method in the US for the past 100 years, and we will touch on that as an introduction. But today's program will be talking to other project delivery approaches that owners over the years have utilized in regards to making sure that they have their projects in place and their facilities constructed. So we will talk about these alternative methods of project delivery. So we'll talk about construction management at risk, construction management with an agent, program management, design build, and integrated project delivery. Integrated project delivery is the most recent development that we've seen to date, but we will talk at the end. But to begin the discussion, let's talk briefly about some of the concepts in the more traditional design, award, build method of project delivery. This is by far the most common method still to this date. And in a design, award, build project, the owner enters into an agreement with the design professional, with the architect or engineer, for design services and preparation of bid and construction documents. Once the owner gets these documents after a competitive bid or negotiation process, the client, the owner, contracts with a contractor. During construction, the AE, the design professional, administers a construction contract on behalf of the client. Now, the client, having furnished the contract documents to the contractor, is in essence warranting by implication that the project is constructible and that the documents in the contract documents have all of the information that the contractor needs to complete the project. This doctrine is known as the Spearman doctrine, and it means that if there's information that is missing in these documents, that the owner is obligated to make to pay the contractor for that missing information. Some of these alternate project delivery vehicles that we're talking about were really developed to try to address some of the deficiencies from the owner's standpoint in having them issue that implied warranty, that Spearman doctrine. So that's why I thought it was important to talk about it here in the initial design, award, build phase. The other thing that the design, award, build project delivery affords the client is an independent relationship between the architect, engineer, and contractor. They do not have a contractual relationship, and what that means is that it essentially creates a system of checks and balances that protects client and public, because the design professional is not obligated to the contractor, but instead has independent duties to the client, and it's fairly easy, therefore, to make sure that the loyalty of the design professional remains with the client. With all of these advantages, there are certain liability issues or risk issues that the client is concerned about. One of the things from the client, from the owner's standpoint, is that the design professional may not pay sufficient attention to constructability, schedule, and cost considerations. After all, the design professional is providing a design solution, and the perception amongst owners was that really, when it came to the nitty-gritty of making sure that this job can be done in a manner that is feasible and meets cost constraints and schedule, that the design professional wasn't necessarily incentivized to deliver on behalf of the client. During the construction phase, there may be problems that may arise in connection with safety methods. The alleged unwarranted involvement of the design professional in the contractor's chosen means and methods could be a source of conflict. Even though traditionally the AE has no role in construction means and methods, there could still be disagreement about what the appropriate solution should be for the construction. The alleged wrongful failure of the design professional to approve contractor value engineering proposals or substitutions. This may lead to issues for the client not being able to realize cost savings because the design professional is not properly evaluating the substitutions that are being suggested by the contractor. Disputes over the value or quantity of work performed by the contractor, that's certainly been an issue during the construction phase. And the validity of contractors' claims for additional compensation or time extensions with the role of the design professional, that could certainly complicate the resolution of these items, all of which led to issues for clients making sure that their projects come in on time and under budget. And during and after construction, if the client alleges that the design professional was negligent for failing to observe and report defective work by the contractor, that could lead to an additional liability issue for the design professional. So those were some of the challenges that led to the development of other project delivery vehicles methods as we see them over the years, and that's what we're intending to talk about today. Now, these issues, of course, can be mitigated through the proper division of responsibility between the design professional and the contractor. So if you have a careful definition of the design professional's responsibility in the professional services agreement, and make sure that the agreement with your client, the design professional, is coordinated with the responsibilities as specified in the contractor and owner agreement, as long as there's coordination, to some extent, these problems can be mitigated and managed successfully. Nevertheless, over the years, the industry has developed separate ways of delivering these types of projects, and that's what we'll be talking about from this point on. So the first issue that we're going to discuss is at-risk construction management, and let's look at a visual to illustrate what this looks like. With an at-risk construction management approach, the owner has separate contracts with the design professional, the AE, and one with the at-risk construction manager, who will have subcontractors underneath them. Now, there are several ways to define the term construction manager. Depending on the definition, the role and liability exposure of design professionals serving as a construction manager can change dramatically. From what we've seen, generally, design professionals don't perform the at-risk construction management role. This is a construction manager who typically possesses the experience and ability to supervise and control the work of trade workers, as well as the financial capacity to secure surety bonds when required by the client. And even if the design firms that we currently work with, that we typically work with, want to go this route, there are practical limitations about their ability to take on this responsibility. However, we do have a few firms that do this, and it is possible, but it is not a typical role. So, with that said, the at-risk construction managers' front-end or pre-construction services often include constructability review of the design documents, value analysis studies on major construction components, development of construction cost estimates and construction schedules, recommendations concerning early procurement of long lead construction materials or components. So what that means is that the design professional is still providing services, consulting services to the client. And when those are presented to the owner, the construction manager isn't just involved in providing a bid or negotiating a proposal to enter into a contract. They're actually reviewing it, providing input, and making sure that the owner gets the benefit of the the construction manager's expertise. This is a significant benefit to the client who wants to make sure that the facility is indeed something that can be done reasonably and it does not involve a lot of back and forth because all of these issues have been identified by the at-risk construction manager. There are standard form documents that describe this role if you're interested in further exploring what these agreements look like. But they're published by the AIA, the Consensus Docs, and the Construction Management Association of America. Obviously, each of these forms reflect the perspective of the publisher, but an at-risk CM approach, if that is indeed what you are dealing with, oftentimes, more likely than not, you as a design firm are providing independent services to the client, and you're working with somebody who's comfortable in taking on the role of being at risk for the construction aspect of the project, and is comfortable supervising the trade contractors and assuming business risk to make sure that the project gets completed on time and under budget. And if it doesn't, then that business risk falls on the at-risk construction manager. For you all, for the design firm in this process, your risks really are not that much different from what you have in a traditional design award build project methodology. The more common role for design firms such as yours when it relates to construction management is to take on agency construction management services. And if you look at a visual representation, this is what it looks like. There's still an independent design professional, an AE, who's providing design services, but as an agency construction manager, you are acting as a representative and agent of the client. And typically, that's the project owner. And you're commonly known as the agency construction manager. This can be provided by a design professional or a contractor. And typically, you're providing services under a direct agreement with the client, and you're independent of both the design professional and the general contractor or separate trade contractors that the owner engages with. So, from a risk management standpoint, it is important that the roles and responsibilities of the design professional and construction manager are adequately defined in your respective agreements with the client and in the construction contract general conditions. It is especially important that these documents define which entity, is it going to be the design professional or the construction manager, has the final authority regarding issues such as design decisions, interpretation of the documents, responses to RFIs during the construction phase, review of shop drawings, observation of the construction, contractor payment requests, and communication with the contractor. Who handles that? Is it going to be the agency construction manager, or is it going to be the design firm that is providing traditional design services? Be alert to the implications of an owner bringing in a CM, a construction manager, whether it's at risk or agency, without having addressed these relationships in your agreement, in the agreement that you have with the owner. Because it does mean that the scope of services could be different. If it's not properly clarified as to who's doing what we've often seen is the construction manager pointing fingers at either the contractor or the design firm, because it is not exactly clear who's providing, who's responsible for a certain aspect of the services. So you really need to make sure that if the owner decides to use a construction manager, that your agreement properly reflects what what your role is and what the role of the construction manager is going to be. Agency construction management is not something that is fairly familiar to a good number of our firms. Many of design professionals provide agency construction management services, or indeed expand the scope of their traditional design services to the following areas to provide these services to the client. You could be providing detailed cost estimating, scheduling services, constructability reviews, recommendations to the client concerning proposed construction means and methods. You'd be involved in identifying long lead items for pre-purchase. You'll be involved in scheduling, sequencing, and coordination of bidding and negotiation with the various contractors, coordinating the general condition items, and coordinating separate contractors. Truth be told, many public and private clients are requesting or expecting such a broad range of services from traditional design firms. And if you're well prepared and qualified to provide these services, it can be very rewarding. However, there are increased risks to providing these types of services. You have general greater liability exposure for safety, site safety issues, construction means and methods, because you're providing feedback on what the proposed solutions are. That does expose you to more liability, constructability issues that may arise, scheduling, and cost-related issues that were not identified when you're providing these services that the owner may feel that you should properly have pointed out to them while you're providing these services. So to reduce your exposure, and we think that this can be managed and minimized, you should have appropriate contractual provisions that appropriately protect you. Your contract should clearly state that your status, the construction manager's status, is as an agent of the client, and limit your obligations for safety programs and precautions, construction means and methods, and constructability review. You should only owe your client, if you are the construction manager acting in the agency position, only owe the client a duty on schedule and cost issues, not the contractor or anybody else, right? You should also disclaim any third-party beneficiary status related to the construction manager's performance and obligations, and allocate risk to the contractor and its subcontractors for claims relating to safety and construction means and methods. Most PL insurance policies, including ours, will provide coverage for claims that arise out of your agency construction management services that you provide. It does not provide coverage for claims arising out of non-professional advice or services including the actual performance of construction work by you or others directly retained by you. So just be aware that if you are going beyond providing agency CM services and assuming responsibility for construction, that is indeed a business risk that is not covered by insurance. There are standard form agreements available for agency construction management that you can review. They're published by the AIA, the Consensus Docs, and the Construction Management Association of America organizations. So you can certainly look through those and identify what those look like, but that is something that clients increasingly are using to manage the program to build their facilities. The next topic that I want to talk about is program management. And it can be grouped into the 5 categories that you see here. You're essentially acting as an extension of the client staff, rendering advice on such topics as the project delivery approach, schedule control, claim prevention, budgeting, public relations, risk and insurance management. These types of services relate to what the owner is trying to accomplish. You could be involved in, let's say, land acquisition and site development issues, tracking of changes, and planning for use of the completed project. Project management services, again, depend on how these services are defined in your program, but they're most frequently employed on large projects involving many complex stacks or sub-projects such as airports or multi-building schools. So large universities may engage a program manager to, over the years, manage the facility expansion plans for the owner. In addition, program management has an increasing role in privatization efforts by government entities. So it is certainly not going away. For firms that are indeed providing these more general services, you remember that you will be expected to know more than just the average program manager because you are a licensed design professional. So you should pay special attention to contract provisions regarding safety, insurance, and licensing matters to make sure that indeed what you're taking on is reasonable and doesn't go beyond what it is that you expect to do. But ultimately, resolution of these issues really depends upon the specific nature of your role, your business qualifications, and whether or not you are effectively managing these risks. There are standard form documents available for program management. They're published by the Consensus Docs folks and the Engineers Joint Contract Documents Committee as well. So again, if you're looking for outside resources, that is available out there as standard form documents. So the next major alternative project delivery vehicle that we want to talk about is design build. And really, this combines the design and build roles responsibilities to a single entity. Some clients prefer the design build approach because a single entity may be held accountable for both the design and construction. There's a single point of responsibility, and clients may well be interested in just dealing with one contract, one entity, and be done with it. There's a number of important risk management considerations that arise for design professionals if you're looking at being involved in design build if you haven't been involved already. You need to identify what the role of the design professional is in the design build entity, and we'll talk about that. The contractual provisions for the project, any licensing issues, insurance and surety bonding issues, and what your liability exposure could be. And usually the business issues are different from those of the traditional design firm, and we'll talk about that. So for design firms, there are three different roles that you may undertake. And that will significantly influence the nature and extent of your potential liability exposure. You could be acting as a prime, a design professional as a prime. B, design professional and the contractor, the builder, enter into a joint venture. Or C, you could be a sub to the contractor, so that the design firm is acting as a subcontractor to the design build entity. So let's look at A, where you, the design firm, have the prime contractual relationship with the client and frontline responsibility for both design and construction. If indeed you are taking this on, you may subcontract this to a construction contractor to do the build, or construction portion and still assume the prime responsibility. So you are basically subbing it off if you don't have contractor capabilities in-house. So if you are indeed taking this on, you have, of course, liability for professional negligence that goes with it. But the thing that is radically different is now you're responsible for warranties and guarantees, because you're responsible for both the design and construction that goes with it. So you're also responsible for the indemnity obligations of a builder. And there may be strict liability and product liability exposure, as well as increased exposure under federal and state environmental and safety laws and regulations, because you're now acting as the contractor who's assumed responsibility for the site and therefore is expected to own the project. As somebody who has assumed responsibility for a site, remember that if there is a sudden collapse, or if there are dangerous activities such as demolition or anything of that nature, and something happens, you may be held responsible under strict liability theories as opposed to the traditional common law negligence concepts, because you are engaged in inherently dangerous activities. So the exposure risk certainly is increased dramatically. And for that reason, we don't really see a whole lot of firms who are willing to take on that role, although some large firms do take on that role of being the prime. And depending on the state, remember that you may need to be licensed as a contractor to have these types of responsibilities. So the following are generally not insurable, right? Statutory fines and penalties that you may be subjected to, business risks such as subcontractor defaults and payment problems, liquidated damages. These types of exposures that you may well have are not covered by insurance, and any additional performance costs that are caused by unanticipated conditions. So most of the enhanced risk is really not covered by insurance. So if you are indeed contemplating this, you would have to learn to think like a contractor. For many design firms, this is really a major transformation in your perspective on the design and construction process. In particular, in terms of how risk should be allocated between the client and the contractor. Instead of being the client's representative, as in the traditional design, award, build, delivery approach, your role under role A is that to have, you're going to have an arm's length relationship with the client. And therefore, there may be greater economic tensions between the client and the design firm, now the design builder, right? You should also focus on certain risks such as time and cost risks associated with encountering concealed or unanticipated surface conditions. This is a constant consideration of contractors, but traditionally it has not been a subject of business concern really for the design professional, beyond making sure that the survey reflects what is out there and designing a solution based on the information available to you. If there is indeed something that is unexpected, that usually does not mean that that does not entail a business risk for you so in the role of a design firm. For a contractor, however, there are major implications about cost and time, making sure that they meet their obligations. So that is a totally different risk profile for a design builder assuming that role. So, for design firms contemplating that, that is often a big cultural change. As I said earlier, though, we don't see a whole lot of design firms stepping up into this role, into role A, to become a prime in a design build project. The next role that we see is where the design firm may enter into a joint venture with a construction contractor and together be primarily responsible to the client for design and construction of the project. Under this approach, you typically perform you being the design firm, typically perform the traditional design services, and a construction contractor, as part of the joint venture, actually constructs the project. This is certainly more common, especially when you're pursuing a project. You may well enter into a joint venture to pursue it, and when you get it, enter into a joint venture to complete the project. In this role, you, as part of the joint venture with a construction contractor, face much of the same enhanced liability risk and exposure as under Role A. Although the scope of your service obligations may be specifically defined in your joint venture agreement, both the design firm and the joint venture partner, the contractor, are considered jointly and severally liable to the client for the entire design and build obligation. So under both roles A and B, it is a good idea for you, the design firm, to contractually transfer some of the risk to other entities involved in the team through indemnity provisions, insurance, and bond requirements. Specifically, you should require the contractor to indemnify you for risks associated with the build portion of the undertaking. At least if you are dealing with a reputable partner, you do have some protection for any joint liability concerns that may arise because of your agreement they will make you whole for any issues related to the construction portion of the project. And you should also, of course, require that the contractor obtain appropriate general liability coverage, including contractual liability coverage. And you should always engage your insurance advisors before engaging in these activities. The contractor and subcontractor should also be required to purchase performance and payment bonds that will, in effect, ensure the performance and payment obligations of the contractor. However, as I said before, not all of the enhanced risks associated with roles A and B may be transferred entirely to the contractor or its insurance. So that is certainly something to consider. We certainly see more joint venture activity by design firms than we do design firms taking on the role of prime in a design build project. So the last piece that we need to talk about is the most common one, where the design builder has the relationship and the design team, your firm, is acting as a sub. The construction contractor has the prime contractual relationship with the client and has frontline responsibility for both design and construction. In turn, then, the contractor retains you to provide traditional design and certain construction phase services. This really represents the most conservative and traditional role and level of involvement for a design firm, and we see this as the most common arrangement in our experience. For the design firm, this really does not create any more risk than that assumed under a design award build approach, because you're just engaged for design services. But you have to be wary of flow down provisions in the design builder AE agreement, because if indeed the design builder has certain obligations to the owner and they're flowing all of them down, then those warranty and guarantee obligations certainly exceed those normally undertaken by a design firm. So be wary of warranty obligations and be wary of broad indemnity obligations that the design builder may seek to flow down to you. The one thing that is different is that in this role, you're not acting as a representative of the client. Because of the direct contractual relationship with the contractor, certain services traditionally performed by the design firm during the construction phase, like review of payment requests and the quality of the work, may be eliminated from your scope of services. So we'll touch on that again in this next slide, because in none of the three design build roles we just discussed, the design firm does not act as a representative of the client, of the owner. This can be a weakness because the client doesn't have someone to independently determine if the contractor is doing the job well or as promised. And this could result in substandard work or in excessive payments being made early in the project, or slow payments or non-payments of subcontractors. Both in the EJCDC consensus docs and the Design Build Institute of America each publish families of standard form agreements for use in design build project delivery. And as with all standard agreements, be aware of the need to tailor these agreement forms to project-specific requirements. And there are many resources now that are available to you to learn more about design build projects and methodologies. One of the concepts that I thought was important that we should discuss is bridging, to address some of the concerns that the owner has about not having an independent design firm. And bridging really, it's intended to, if you have an AE serving as a bridging consultant, it's intended to achieve the perceived single point advantages of design build while making sure that the client has design professional representation that is independent of the design build entity. So the risk management issues for the architect engineer under the bridging approach vary depending upon the duties and obligations and whether the architect engineer was retained by the client or by the design builder. So if the client wishes to retain a design professional separate from the design build team to represent the interests and of their client independently from the design and construction process, they certainly can, and that's often called the bridging consultant. So they may engage an AE to assist in the development of a program, prepare performance requirements or design criteria, assist in the selection of a design builder, and review the construction documents that are prepared by the AE who is part of the design build team, so that the owner really has the benefit of somebody who can act solely, who has loyalty solely to the owner and is not part of the design build team. The reason this is important is that lenders occasionally will not accept an affidavit or certification of a design build professional of a firm that's been working under the design builder. So they want to see the involvement of an independent design professional. So clients need to be made aware that you don't want to be trying to get a certification at the end of the project from a member of a design team that's under the design builder. We've often seen firms who work for the design builder and are being asked to certify conditions to the owner's lender, but that's really not part of their scope of services, or nor does it meet the lender's requirements. So just be aware of those nuances. So from a risk management standpoint, if you are serving as a bridging consultant to the client, it does raise certain concerns. So it really should be specified as to what the nature, purpose, and extent of your review of any design or construction document or other work product of the design builder should be carefully and clearly defined in your agreement with the client. Under no circumstances, really, should you as an independent design professional stamp or seal the construction documents prepared by the design builder because they were prepared under the supervision of somebody else. Ultimately, the design builder should have the responsibility for the design and construction of the project. So you, as the independent design professional, may try, in the interest of the client, to influence the design builder's design decisions, but you should not impose your design judgments on the design builder. Especially if you're developing bridging documents, you want to be able to give the design builder enough flexibility to come up with solutions on their own. Otherwise, you may be construed to have assumed some level of responsibility for the design. If the client wants you to review shop drawings or other submittals, this should be done only after the design builder has reviewed and stamped the shop drawing. And it should be made clear that the independent design professional is undertaking such review solely for the benefit of the client. You should not communicate with contractors or subcontractors on any aspect of the project so that there's role clarity about your responsibilities. If you will be required to review or certify construction, it is critical that the nature and purpose of the review or certification be clearly defined and that the independent design professional satisfy himself that his on-site role is sufficient to enable him to certify as to what certain construction conditions are like. So if indeed you are expected to certify about substantial completion or whether construction was done in a certain manner to be able to get certificate of occupancy and so on, make sure that indeed it is clearly stated what your role is and that you have done the necessary services to be able to certify as to those conditions. Again, these concerns can be addressed contractually by making sure that your scope of services is done correctly. If you are on the other side, if you're working for the design builder as a design firm, you have to make sure to maintain your independence and your loyalty to the design builder. So typically what the independent design professional will provide you, the design builder's firm, is performance requirements, standards, design criteria, or other base elements that must be incorporated into the design. Although the independent design professional will be responsible for what they develop, you will also be responsible under the design builder for what is incorporated into the design, final design drawing, because you now assume responsibility for that. And you're the one who will be stamping those construction documents, signing and sealing them. So if you, as the design builder's design professional, have any reservations about any of the recommendations, then you certainly should not be accepting or incorporating them into the final design, because ultimately it's going to be your responsibility. And even though the client's independent design professional may review design, development, or construction documents, don't expect them to share any liability for errors and omissions in those documents, because it will be most likely have been held to be prepared under your supervision. During the construction phase, the design builder's design firm should probably have the primary and perhaps exclusive communication and administrative role in the project, especially with the contractor. I think it's important that the client's independent design professional should have no project status other than as an advisor to the client. Because the involvement of two separate design professionals during construction could significantly increase the likelihood of confusion, ambiguity, and conflict in the construction process, and that leads to problems. So to that end, you should not, you being the design builder's design professional, should not accept any direction from the client's independent design professional, but the design builders that you consider ill-advised. Ultimately, to reiterate, the final responsibility for the final design and construction rests with the design build team, including you, the design professional. You won't be able to avoid any liability by pointing to the design changes or decisions made by the client's independent design professional. So I think bridging does enhance the design build approach by introducing an independent architect engineer to represent the client, but obviously the respective roles and responsibilities of the client's design professional and the design builder's design professional must be clearly defined, appropriately allocated, and well documented. So that really is what we wanted to say about design build. And the next topic we want to talk about is integrated project delivery, which really came to the forefront due to the AIA's involvement around 10, 12 years ago to try to make improvement to the way capital projects are designed and built, and to try to see if there's more ways of collaborating instead of having independent contractual relationships between the owner and the architect and the owner and the builder. So as we see here, you can have variable contractual relationships between the designer and the constructor in integrated project delivery. You could have more or less a traditional owner architect engineer and owner contractor relationship that is more or less the same as a design award build, or you can have a tri-party agreement between the owner, architect, and the contractor, or you could have a single purpose entity theoretically between the owner, the construction manager, and the architect engineer to form a special purpose entity to do the project. We do see the first and second much more commonly than the special purpose entity approach, but at least theoretically you could have that. And so with IPD, the goal is to have a contractual team to put a capital asset in place that breaks down separate contract barriers and protections so that folks are working towards the end goal and are working collaboratively, and that's described in the document. So it's designed to integrate people, systems, business structures, and practices into a process that collaboratively harnesses the talents and insights of all participants to optimize project results and increase value to the owner, reduce waste, maximize efficiency through all phases of design, fabrication, and construction. And if indeed it is an IPD, it may reduce the effect of the spirit and case law, because generally speaking, the intent is to have all of the parties working towards the same goal instead of relying on warranty and guarantee obligations. So how is that done? Generally speaking, what is intended to happen is you establish a baseline target for what the project cost and schedule is going to look like. And if the actual cost exceeds that project target cost estimate, that loss then is shared by the parties. If it comes in at or below those estimates, then you are rewarded for that enhanced performance. And so your obligation is to work collaboratively and be part of the solution. This is obviously intended to incentivize the design firm and the contractor to solve solutions, but it does present business risks that could jeopardize the firm. So most of the risks that we see in the IPD documents that we review are business risks. They're really not insurance-related matters. This is obviously being driven by technological innovations that are changing design and construction. And there are challenges to these delivery vehicles. And outside of certain sectors, we're not really seeing IPD being undertaken as a matter of mainstream projects, but that could well shift. There are untested contractual relationships that are happening because they're client-generated agreements, and most of the risks that you face are business in nature. And it does challenge your business model or practice, cash flow, profits, and asset risk that design firms have to account for. Some of the things that we should be thinking about is what is the legal treatment of IPD. We know what the case law on negligence are, and we can use that as a framework, but really this is still new and it hasn't really been tested in courts. So if you're sharing about shared responsibilities for both design and construction between different entities, how does that work with our current regulatory scheme as far as statutes and registration laws, and how does the case law reflect on those responsibilities? The insurance coverage piece has been addressed for the most part with project insurance solutions, but there's still the issue of contractual exposures that need to be thought about. And essentially, inherently, you are engaged in speculative risks that may not be covered by insurance. And then finally, the financial system may not be as willing to finance IPD projects, although that is also not as much of a problem anymore, because the banks really want to see who the contracting entity is, who's responsible, and whether it is indeed a worthy project to finance. With IPD and some of the shared risks, there may be questions about traditional financing schemes, although the industry is certainly providing solutions to that. So those are the alternative project delivery mechanisms that we wanted to bring and highlight to you. As I said, I haven't been able to get into any of the questions, but I will be reviewing any questions that come in and responding. For more information, we urge you to visit our website. Here's a look at our new website. And if you have not already established an account, you should do so. Once you register, you can view claim studies, practice management information, contract language, and commentary, past webinars, which can now provide CEUs, and much, much more.